Good evening. I'm Bob Friedman. Thank you for joining us this evening. We're covering 5 topics today. The first will be the Tenant Protection Act of 2019. Even though it's been in existence for 2 years, we're finding that many clients are not aware of what's required by the Tenant Protection Act of 2019. The second topic, Justin Friedman will cover a moratorium update and real life examples of how to evict tenants now. Next, we'll also be covering the Emergency Rental Assistance Program and how to recover rents. And Russ Gullo will be covering how to know when to sell investment property. I just have a few warnings before we get started. This is not a substitute for legal advice. The laws are constantly changing and subject to different interpretations. You need to consult with your own attorney to see what's best in your particular situation. We have a tremendous amount of material to cover in just 1 hour. However, this video, as well as additional information, will be available on our wny-lawyers.com website. Please feel free to post questions, which we will answer at the end. And if you have any additional questions, feel free to email us or call us. The last 2 years have been very rough for landlords, beginning in June of 2019 when the Tenant Protection Act of 2019 was passed, which significantly limited the landlord's rights. And then since the onset of the pandemic in March of 2020, there have been court closures, stays of evictions, and a very slow rollout of government funds for rent relief, which has frustrated and burdened many landlords. So in order to properly evict tenants, I'm going to review some of the highlights of the New York Tenant Protection Act of 2019, which people find to be very confusing, and there seems to be quite a bit of misinformation. First off, if the tenant is more than 5 days delinquent in payment of rent, you are required to send a notice to the tenant by certified mail. Also, what was formerly the 3-day non-payment notice, you are now required to serve the tenant with a 14-day notice for non-payment of rent. And notice of petition, and petition must be served 10 to 17 days before the court date, rather than the previous time frame of 5 to 12 days. Either party can request an adjournment of at least 14 days. If the tenant defaults, does not appear in court, attorney's fees cannot be awarded. Warrants give tenants 14 days now instead of 72 hours notice to vacate. The tenant can terminate the proceedings by paying all rent due before the warrant is executed. And the warrant can be stayed for up to 1 year in hardship cases. Late fees are now limited to the lesser of $50 or 5% of the monthly rent, which we begin the 6th day after rent is due. Application fees cannot be charged, and there's a limit of $20 charge for credit reports. Also, if a tenant breaks the lease early, landlords have a duty to mitigate their damages. That means they must make all efforts to re-rent the property. The presumption of retaliatory eviction, which is one of the few defenses that tenants have to holdover evictions, has been expanded to include when a tenant complains about conditions to the landlord. It used to be just the presumption of retaliatory eviction when the tenant complained to a government authority, such as the health department or the building inspectors. This next item is an important thing to keep in mind because holdover evictions might be the most clear-cut route to evicting a tenant. And notices of non-renewal or termination of month-to-month residential tenancies must be delivered to the tenant if the tenant's been there for less than 1 year on 30 days notice, if the tenant's been there for more than 1 year, but less than 2 years on 60 days notice, and more than 2 years on 90 days notice. So whether it's a month-to-month or a fixed term lease, you must provide a notice of either non-renewal or termination. Previously, prior to 2019, you were not required to give a notice to the tenant on a fixed term lease. And rent for purposes of an eviction does not include late charges, interest, or other fees. So previously, landlords could evict the tenants even though they paid the base rent if they failed to pay late charges or attorney's fees or repair fees and so forth. Now you can only base the eviction non-payment of rent, and you may have to pursue the other damages and expenses through small claims court. Now there's, I've always recommended move-in, move-out inspections. Now those are required. And security deposits must be returned within 14 days after the tenant vacates the apartment. And this would be for either that or provide them an itemization of what is being deducted for them security deposit. If you fail to return the security deposit or notification within 14 days, then the tenant would be entitled to the return of a security deposit, regardless of the amount of damages, and additionally triple damages. Justin Friedman will be giving an update on the federal and state eviction moratoriums.
So since last we met a couple of weeks ago, there have been some changes in everything from federal legislation to individual court rules and policies that are affecting landlords' ability to evict tenants. I talk to landlords every day, and what they want to know is it even possible right now? And my answer is always that it depends. I think now more so than 2 weeks ago, there's a sort of positive trend towards greater ability to get some action as far as getting these cases in front of a court. So what it's really going to depend on is number one is where the eviction is taking place. Depending on how much of a backlog there is, whether or not an individual court is accepting petitions, this is all going to affect whether or not we can get this in front of a judge and have an eviction. Now, when we last spoke, the Buffalo City Court had not been scheduling any evictions. In that 2 weeks, there's been a lot of positive movement. And, a lot of it depends on when the petition was filed. Now, sort of counterintuitively, there are some petitions that I filed in Buffalo City Court, almost a year ago that I've just gotten dates on, whereas petitions I filed a couple months ago, I've gotten dates on, much earlier. And that's all because the proceedings of the court is giving precedence to, there have been nuisance allegations made. So that's another important consideration as to whether or not you can evict someone, is whether or not the tenant is being a nuisance. And that has a very specific definition that we're going to talk about in a little while. Another consideration is whether or not the tenant makes a declaration of financial hardship. If the tenant makes a declaration of financial hardship, then they are going to be covered under the CDC Moratorium, which may prevent you from evicting the tenant. And finally, most importantly, is your ability to evict a tenant is whether or not the petition you submit is sufficient, if it contains all of the parts, all the additional pleadings and affidavits that are required, both under the Tenant Protection Act that Bob was just talking about and under the New York Emergency Eviction Prevention Act of 2020. So the first new affidavit that any petition is going to need to include is just a sort of general affidavit, and there's forms you can find online, and we have it right here as a part of the slideshow, that your petition is consistent with all of the new eviction laws. And if you have an attorney do that, the attorney can fill that out and sign that. It looks just like this. Again, it's a form. You can print it probably right off of this presentation, or it's available on the New York Court's website. Again, this is just an affirmation, affirming that the petition contains everything that it needs to. And then there's also a version of that for the landlord. If you do not hire a attorney to submit the petition, you can fill out this affidavit as well. If you're doing it yourself and it's not an attorney, it will have to be notarized. And that's right there for you. See, in addition, that administrative order that requires this affidavit also requires that these notices that the tenant may be eligible for an extension of time to respond. That also needs to be included in the petition. Some courts, again, there are different court rules. Some courts I know in Rochester, in Monroe County in general, they require that these notices be in a different color other than white. I haven't heard that anywhere else, but just erring on the side of caution, I always print these out in a color other than white to catch the tenant's attention. In addition to these administrative orders, the Emergency Prevention Act of 2020 has required a number of additional materials to be provided in a petition. And this was effective as of December 28th, 2020. And any eviction that you initiate from that point onward needs to include a hardship declaration. So it is now the tenant's or the landlord's responsibility to serve on the tenant a notice and a declaration of hardship. The hardship will allow them to declare that they either have a financial or a health-related hardship that prevents them from moving. Now, this was originally supposed to be up April 31st. That's been extended to August 31st. It could potentially be extended again. With talk of this new Delta variant, depending on if rates go up. I'm just operating under the assumption that this is going to be extended. So even notices that I send out that have a termination period beyond September 1st, I'm including the hardship declaration. And that's the notice and the hardship declaration we have here for you as well. You'll notice on the hardship declaration, it's just a box that you check. A lot of landlords tell me, oh, my tenant's been working the whole time. They're not having a financial hardship. But as you can see from this form here, financial hardship is not limited to simply being out of work. It could be incidental costs associated with the coronavirus pandemic, such as childcare. It could be moving costs, or it could be at the top of page 9 there is just other circumstances. And then you can see below that the tenant can check off that they're having a health-related issue as well. Now, if the tenant fills this out and returns it to the court, to the landlord, or to the court's attorney, right now that is going to be stayed until at least September 1st, unless the landlord can make allegations of the tenants being a nuisance, and then that would be an exception to this. We'll talk about that in a second. Now, along with this hardship declaration, you're now also required to serve a list of free legal service providers. The one I have here is for the 8th Judicial District, which includes Erie County, Allegheny County, Chautauqua County, Orleans County, all the counties, Niagara County. If you're in Rochester or in the 7th Judicial District, there is a separate form that has legal service providers in those counties, and that's available on the New York Court's website. We don't have it here, but this is what the list for the 8th Judicial Districts looks like. We have that, and then an additional list with the websites on it. I think the next 2 slides are repeats if you just want to. Oh, right here. This is the specific to Buffalo City Court. What I just showed you, if you're serving a notice in the city of Buffalo, you would not include the list I just showed you. It's Buffalo requires this list. I've actually had petitions turned away and said, no, you need to serve it with this particular list, even though all of these providers are on the list I just showed you. Buffalo City Court wants this one. They're very particular. So if you're serving notice in the city of Buffalo, make sure that this list in Spanish and English is included. Okay, so again, that needs to be, just go to the next 2. We had that one already, I believe. Sorry, the Tenant Safe Harbor Act. I guess, sorry, I'm giving that the short shrift. That began June 30th, 2020, almost a year ago, and was only to last until all COVID-related restrictions are lifted. Cuomo declared there's no longer a state of emergency, so I don't believe that this applies anymore. However, you cannot initiate an eviction for non-payment based on any rents that were not paid between July of 2020 and the day June 24th, when the state of emergency was lifted. Again, we didn't really see this at play much because it was essentially swallowed by the Emergency Eviction Prevention Act, which we've been talking about. So again, with that Emergency Eviction Prevention Act, you need to serve that hardship declaration and that list with the notices. And when you serve the petition, you're going to need to include that hardship declaration and that list and an affidavit of service of the list and the hardship declaration. That needs to be served the same way that you would serve the notice. And again, you're going to have to provide an affidavit of that as well. Along with the petition, you will need to include a affidavit that you either did not receive the hardship declaration back, or that the tenant is exempt from the moratorium because they're a nuisance. And you have to give specific examples of that nuisance, and it's not a nuisance just in the everyday sense of the word. It means that the tenant has persistently and unreasonably engaged in behavior that substantially infringes on the use and enjoyment of other tenants or occupants, or causes substantial safety hazard to others, and then with a specific description of that behavior. Now, this is where we've had some degree of success in getting warrants in making nuisance allegations. Again, it's going to depend on the court to determine, whether or not there's a nuisance. In Niagara Falls, we took pictures of garbage and trash outside someone's house. We had witnesses say that it was attracting vermin, and the judge granted the warrant based on that nuisance. In another court in a small town, we had a tenant who was chain smoking in the apartment, and she had an oxygen tank, and she actually had set the place on fire before we brought the action. We were successful in getting a warrant there, but the judge said the only reason we were is because there were other occupants and because the tenant had already demonstrated that she was a fire hazard. So in that case, allegations of simply garbage being left about probably, would not have flown there. Once you get that warrant, it's important to also note that the warrant is going to have to include that same language that's included in these affidavits, either that there was a hardship notice served and you provide the date of the hardship notice, or that the tenant is subject to the nuisance exception. So, it might be helpful to have those warrants prepared with that language, because not all courts have those warrants. I had a form warrant signed by a judge in a town justice court. I said I brought my own warrant. They said, no, it's okay, we have it. And then the sheriff wouldn't serve it because it didn't contain that language that we just talked about on the warrant. So that needs to be on everything from the the petition to the warrant if you want the sheriff to serve it. Finally, the latest update is that the CDC moratorium, which I think a lot of people are concerned about, perhaps more than they should be, because it's national news and you see more about this. That's been extended till July 31st. It's not likely to be extended beyond that. They said that that's the end of it. Again, this applies only to non-payment proceedings. And again, that's swallowed by the Emergency Eviction Prevention Act of 2020 in New York State, which applies to all evictions, not just non-payment proceedings. So just as a final word, I know this is entirely very frustrating. It is still a criminal offense. It's a misdemeanor to engage in any self-help eviction by shutting off utilities or attempting to lock your tenant out. So just be conscious of that, and don't try to take the law into your own hands. Use the courts; they are slowly opening up. In the event that you do get a date and the tenant has sent in a hardship application and you haven't made the nuisance exception, I've also found it's helpful to just negotiate with the tenant. We've managed to get some conditional warrants granted where the tenant stipulates that they will be out by a certain date. And if not, then the warrant will issue. Sometimes just the threat of that August 31st is coming up soon. Some people don't want this eviction on their record, so they are willing to stipulate to a move out date of that time. So we've had some success there. Sometimes just helps to think out of the box. With that, I'll turn it back over to Bob Friedman, who's going to talk about some ways to get some money with the cooperation of your tenant through the Emergency Rental Assistance Program of 2021.
Prior to the recently activated Emergency Rental Assistance Program of 2021, there was an Emergency Rent Relief Act of 2020 under the CARES Act. And the criteria to qualify was so restrictive that by March of this year, when the program ended, less than 1/2 of the $100 million in funds had been distributed. So we have finally the Emergency Rental Assistance Program of 2021. The application and all the information is on the New York State website. This was supposed to originally go online in March 1st of 21. It just went online June 1st of this month. And to be eligible, your household gross income, it must be at or below 80% of the area median income. And that on or after March 13th of 2020, a member of your household received unemployment benefits or experienced a reduction of income, incurred significant costs, or experienced financial hardship directly or indirectly due to the COVID-19 pandemic. The applicant was a tenant who had to pay rent for their primary residence and has overdue rent on or after March 13th, 2020. And the household must be at risk of experiencing homelessness or housing instability. The priorities for the first 30 days of the program, which is just about up, is our households with income at or below 50% of the area median income. The benefits are up to 12 months of rental arrear payments for rents that accrued after March 13th, 2020, and up to 3 months of additional rental assistance if the household is expected to spend 30% or more of their gross monthly income to pay for rent. And they also pay for up to 12 months of electric or gas utility arrear payments for arrears that have occurred on or after March 13th, 2020. Payments will be made directly to the landlord or the property owner. Landlords as well as tenants must submit financial information, and neither the landlord or the tenant will have access to each other's financial information. Landlords must provide W-9 tax forms, executed leases, documentation of rent due from the tenant, such as a letter or attestation, banking information in order to receive the direct deposit payment. The landlords have to understand that the payment satisfies the tenant's full rental obligations for the time period covered by the payment. You must waive any late fees due on rental arrears and agree not to evict the household. For reason of expired lease or holdover tenancy for 1 year from the receipt of the ERAP payment. Also, another disadvantage to landlords is that if there is an application pending, you can't proceed with a non-payment eviction until a determination is made whether or not they are eligible for the rental assistance. So you may have to wait and see whether they're eligible for the rental assistance before evicting them. If you're uncooperative or can't be located after 21 days, payments will be sent directly to your tenant and not to you. So we just have a few minutes left here, and I have all this information on our website. Again, as usual, I think it helps to maintain as much communication with your tenants as possible, especially if they're unemployed and during these tough times, possibly work out an agreement to defer rent and to accommodate their needs as well as yours. Move in, move out checklists have always been recommended, and I do, and they are required now. And as well as they should take photos and videos of the apartment before the tenant moves out. Before the tenant moves in. So if there is any damage, you will have the necessary proof to recover damages against the tenant. Your leases, you may want to have guarantors sign so that if tenants, for instance, unemployed tenants or college students, so that you can recover against the guarantors for unpaid damages or rent. Have added rent clauses for repairs. As I told you, there's limitations on late charges now on the Tenant Protection Act. Your leases should require the tenant to pay your legal fees if you have to collect from the tenant or evict the tenant. If you are paying for the utilities and you're concerned about additional tenants moving in and using additional utilities, you may have a clause in your lease to increase charges if there's excessive utility charges such as water or electric. Security deposits are now limited to the amount of the monthly rent. Previously, you could charge as much as you wanted for a security deposit. Now that is limited. We also recommend in certain cases that tenants sign confessions of judgment. So if they do violate the leases, you can file judgment against them without having to initiate a court action. You are required to give rent receipts if tenants are paying in any manner other than a check. If a tenant dies during the term of a lease, you can file a claim against the tenant's estate for unpaid rent and damages to the apartment. Tenants' defenses and to either payment of rent or for an eviction is a breach of the warranty of habitability. In all residential units, you have an unqualified obligation to provide an apartment that is safe and not a danger to the tenant's life, health, or safety. That's regardless of what the situation is. You have this obligation, and this can result, if you do breach this warranty of habitability, it could result in the court awarding less of the rent that's due, or maybe not even any of the rent that's due. You can obtain a judgment through an eviction action if the tenant is personally served or appears in court. And if you do get a judgment in the town or village courts, you should file it also with the county clerk. Small claims court. If you're an LLC or a corporation, you can only use commercial claims part, which are in the city courts, and city courts have monetary jurisdiction up to $5,000. Town and village courts, small claims can be brought for up to $3,000. Look at your rental applications, often for skip tracing your tenants to find them in order to sue them. There can be very valuable information in the application. You can serve an information subpoena on the tenant to obtain their asset information. There's various executions that you can use with the judgment, executing their property, income executions or wage garnishments, execution with notice for bank accounts, and restraints on bank accounts. For further information on these topics, visit our website, the landlord-tenant pages. And as I said before, we welcome your questions if you'd like to post your questions on the Q&A, or feel free to call Justin or me if you have any further questions at our office or email us. Russ Gullo, founder of RJ Gullo Companies, which provide real estate investment services, is speaking on how to know when to sell investment property.
Good evening. I'd like to talk about how each and every one of you have the opportunity to double, triple, and in some cases even quadruple your real estate portfolio by using your current real estate equity that you have in your real estate investments today. That all starts by knowing when to sell, when to dispose of your real estate investments. And that being said, I'd like to start by leading off by saying, like our bodies, which require the physical attention to make sure they perform to their fullest, our real estate investments require the same attention and care. And over the course of a holding period, a real estate investment gets soft and forms what we call a diminishing rate of return when the property is held too long in your portfolio. So it's very important to understand how to calculate the value of your real estate investment properties and to know the difference between the equity that you started with when you made that acquisition of that current real estate investment that you hold versus the equity position that you currently have today in your present real estate investments, which may allow you to, again, double, triple, or even quadruple the size of your real estate portfolio with your current equity. I'd like to lead into an example, and that example is an apartment building. We're going to make the assumption that we bought this 12-unit apartment building back in 1983, and purchase price was $240,000. We used an equity or our down payment position of 60, and we mortgaged the difference of 180,000. So in layman's terms, we put 25% down, which represents our $60,000 equity position at the time of acquisition, and we financed the balance of 180,000 by procuring a first mortgage with any lender. And those same terms are pretty similar today. You can actually go to any lender today, and for the most part, they require a 25% down payment, and they will lend you the balance of a 75% LTV or loan to value ratio. So during the holding period, in my example, the asset built additional equity through the principal pay down of a mortgage, which we know that as equity principal or equity pay down, and through also appreciation, which is the increase of value over the holding period. So we have two of the four benefits of a real estate investment working for us simultaneously, and that's the principal pay down of our mortgage and also the increase in value, which is known as appreciation. Knowing when to sell a real estate investment property can help, as I mentioned, double or triple our real estate portfolio, and in some cases even quadruple our position. So in order to take advantage of this opportunity, we need to know how to determine the value of a real estate investment. So I'm going to introduce the concept of ERV, and ERV is nothing more than the income approach to value that both a real estate appraiser, a lender, and an investor will understand when they buy income producing property. And typically anything over a 4-unit, 5 units plus, an appraiser is going to use the income approach to value rather than the market approach. And that value is determined by the income stream that that property produces. So we start with, in our example, the equation called ERV, and we start with I, and I represents the net operating income. R represents the cap rate, which basically is a rate of return in its simplest form, which is extracted from the marketplace based on comparable sales that have sold. And we can determine that by just going to appraisers, going to lenders, and ask them, hey, what's the cap rate for this type of property of this size and this condition today? And by knowing two of the three parts of this formula, we are able to solve for the unknown, what we call the value. All right. So using our same example of our 12-unit apartment building, I'm kind of going to give you that information. So at acquisition in 1983, when we made this acquisition of this 12-unit building, we had a net operating income of $24,000. And just to keep our example simple, I'm using a cap rate of 10. And basically, all you would need to do is divide 0.10, and that would give you the value of $240,000 to support our purchase price. All right, so that again is known as the ERV equation. So using that very same example of our 12-unit apartment building, assuming here it is 2021, and we've increased our income, relying on that same ERV equation, we've increased our net operating income from $24,000 to $37,000. Now, if you apply a cap rate of 7.5 today, which is very conservative for the most part for a building of this size, I know we're involved with a multifamily transaction right now, and I'm being told by the appraisers that realistically we probably use about a 6.6 cap rate versus my example of a 7.5. So you need to understand, the lower the cap rate, the higher the value. Well, let's stick to the cap rate in our example of 7.5. And if you take our new net operating income, because we were able to increase our rents over the course of 1983 to today, we've increased our rents, which means we've increased our value. So if you apply a cap rate in my example of 7.5 or 0.0750, and you divide, just like we did earlier using the ERV equation, we're solving for value. We have a new value in our example of almost $500,000, $493,000 to be exact. So our value has gone from $240,000 to almost $500,000 because we've increased our income. So what does that mean to our equity position? So if you look at our worksheet, our comparison worksheet, 1983 net operating income of $24,000 to today of $37,000. We apply the cap rate. We come up with value because that's the unknown that we're solving for in our ERV equation. So our value goes from 240 to 493,000, and our mortgage position at acquisition was 180,000. Our mortgage today is debt free, so we're fully amortized at this point. We have no debt, but look at what's happened. Our equity position has gone from a 60% from our acquisition in 1983 to an equity position of almost $500,000. So with $500,000 or $493,000 to be exact of our new equity position, in our example today, we have the opportunity to use the same metrics, meaning that if we take the $500,000 and we use that as a down payment of 25% down in borrowing the difference of $1.5 million, we are able to control $2 million worth of real estate by putting the $493,000 down and procuring a 75% loan to value mortgage, which is $1,479,000 for the difference. All right, but keep in mind, this is an example, it's a case study, and in most cases, our cap rate would probably even be lower. And at the R.J. Gullo companies, one of the services that we provide is that of a real estate investment brokerage company, and we would be happy to put our 50+ years of experience to work for you and to provide a free estimate of value to show you what your real estate investments might be worth today versus what they were at acquisition. Okay, so keep that in mind. You can reach us by going to our website, which is rjgullo.com. You can call us. Our corporate headquarters number based in Buffalo, New York is 716-675-1500. So I want to continue with my example here, and I want to show how what you can do with the increased equity position. So again, keep in mind, you bought this asset in 1983, you put 60 grand down, and today that 60 grand has grown to almost $500,000. Now, I'd like to incorporate the concept of leverage, the use of other people's money. So if we take our equity position of 493 and we basically just take 0.25, divide the two numbers, that'll give us a market value that we can control, or what a lender is willing to lend on, and giving us a loan to value in my example of $1,479,000, meaning that we can control a value of $1,972,000, or almost $2 million. So realistically, you can probably control almost 36 apartment units today for that value, realistically. So you're able to not only double, but triple your real estate portfolio, going from 12 units to 36 units. So the bottom line is, would you rather control a 12-unit apartment building in which you're debt-free, that has a value of $493,000, in which you're probably turning over 50% of your cash flow to Uncle Sam in taxation because you have no shelter, you have no interest expense, you have no depreciation to shelter that cash flow, all right? Versus if you're able to go out and buy almost a $2 million asset, and now you're able to pick up a new basis for tax purposes, for depreciation purposes, and now you also have the interest expense deduction plus all your other operating expenses to shelter that cash flow. So by using the same equity position today of $493,000, I want to carry it a step further and not only introduce the concept of leverage, but the concept of a 1031 exchange, which is the opportunity for you to pay no tax when disposing of a real estate investment, okay? And allowing you to control, in my example, $2 million. So how do you keep 100% of your equity when disposing of a real estate investment? You do a 1031 exchange, which allows you to keep 100% of your equity from your disposition, and using that to acquire a much larger property, like my example of $2 million. By not taking advantage of a 1031 exchange, you can lose as much as a third of your selling price to Uncle Sam in the form of taxation. And who wants to do that today? All right, so Section 1031 of the Internal Revenue Code allows owners to dispose of income-producing assets, like an apartment building or any other real estate investment, and to pay no tax when disposing of that property, as long as you acquire another income-producing or investment-held property within 180 days from the closing of what we call your relinquished property. But keep in mind, in order to take advantage of this opportunity of a 1031 exchange, you have to have the 1031 set up before you can dispose of your real estate investment. So at the RJ Gullo Companies, one of the 4 services that we provide is providing the services and helping structure 1031 exchanges, but we do provide services of what's called a qualified intermediary for 1031 services. And we have over 50 years of experience in that arena. And we were one of the original pioneers in that arena, and we've been in business providing that service since actually 1980, okay? So as I mentioned, this type of a transaction, if you wanna be able to take advantage of this best kept secret in real estate, and not only double, triple, but quadruple your real estate investment holdings, and using the equity that you created in my example of 60,000 to almost 500,000, with the use of leverage and the use of a 1031 exchange, you have that opportunity. So in summary, if you're looking to achieve financial independence with the use of real estate as the vehicle to get you there, you can achieve it much quicker by knowing when to sell a real estate investment, okay? In many cases, a current owner of a real estate investment, as I mentioned all along in this presentation, has the opportunity to double, triple, in some cases even quadruple the size of their real estate portfolio by using their current equity. And in our example, in our case study, we actually took you from a 12-unit to a 36-unit apartment building. We took you from an equity position of 60 to 500,000, which you were able to apply with the use of leverage and with the use of a 1031 exchange, because you're not making Uncle Sam your partner and turning over a third of your selling price to Uncle Sam in the form of taxation. So you're able to keep that that $500,000 working for you through the 1031 and acquiring an asset, in our example of a 36 unit apartment building for some 36 units for a total of $2 million in our example. Okay, so the opportunity to double, triple, or quadruple your real estate portfolio can be achieved. So for those of you that have real estate investments and you think the best thing is to be mortgage free and you've owned these assets for 20 and 30 years, that is not the strategy for a real estate investment. That might be your strategy in most cases for your primary residence, for your secondary residence, where you do not want to have a mortgage. And, if you have a fluctuation in your income, your job, something like the pandemic occurs, it's great to be in a position that you're mortgage free. It allows you to sleep nights. But when we're talking real estate investments, if you're not taking advantage of leverage, okay, you're giving up one of the 4 benefits of a real estate investment because you're limiting your tax benefits. All right. And then by incorporating the concept of a 1031, it will get you to that financial mountain much quicker by using both leverage, 1031 exchange, and by knowing when to sell a real estate investment. So if you think the best thing to do is to hold that real estate investment until you're mortgage free, you are definitely having what's called a diminishing rate of return setting in. And not only from the example that I gave this evening from an equity position to show you how you can go from a $60,000 equity position to a $500,000 equity position, but to carry this a step further, and I'll explain that now, being that we have a few minutes. You can take any cash flow analysis program, software program, and you can prove this. Any real estate cash flow analysis program will always take you down to both cash flow before taxes and cash flow after taxes. I'm referring to income taxes. And you're able to project a holding period. And you can take that software and you can project, I want to hold this asset that I'm buying for 5 years, for 10 years, for 15 years, for 20 years, whatever the case may be. And you can take that software and you can go to your bottom line, which is your cash flow after taxes. And you can see when a diminishing rate of return sets in. And you just have to measure the risk that's involved with the real estate investment and the return that you're looking to get based on the reward and the risk factor that's involved with real estate. And you will see year by year that your cash flow on an after-tax basis, and more importantly, what we call your after-tax yield or return, will start to diminish. And that typically happens anywhere between 5 to 10 years of a holding period. So you have to ask yourself, am I getting on an after-tax basis the return that I'm looking to receive with the risk that's involved with real estate as an investment? And anytime after year 1, let me repeat that, anytime after year 1 on an after-tax basis, your cash flow after taxes, or your after-tax yield, I should say, will diminish. Okay, and you can prove that by just taking any real estate investment analysis software and just run a holding period of anywhere from 5 to 10 to 15 years of any time you're doing an acquisition, and you can see when that after-tax return starts to diminish. And the point is, you started with $60,000 in our example, you have $500,000. And what I call a financial physical is very important to have your real estate investments looked at on an annual basis, like our bodies, to make sure they're performing to their fullest financially. And we just proved that in this example tonight. How many of you own real estate for the last 10, 20 years? And again, as I mentioned, you're debt free. And you started with that $60,000 and you're feeling, you know what? This guy's all crazy because my cash flow before taxes has increased. And you're absolutely right. But I guarantee you're giving half of that over to Uncle Sam in the form of taxation each year. And on an after-tax basis, your after-tax yield is diminished after year 1. And again, you can prove that. You don't have to take my word for that. But I would be more than happy to provide a free consultation anytime any of you are interested in buying or selling a real estate investment, or you're interested in learning how to pay no tax through a 1031 exchange. You can go to our website, which is again, rjgullo.com. You can take a look at the services that we provide. Again, we bring over 50 years of experience to the table. And we're more than happy to put that work to work for you, so you can take advantage of our experience and not only what we talked about this evening, but any other questions you may have. As Bob mentioned, we'd be more than happy to address at this time, whether it's from Bob and Justin's presentation or from my presentation. And Bob, I'm going to turn the floor back over to you at this time.
Thank you, Russ. We've answered all the questions that were posted. If there's any further questions, feel free to post them on the Q&A. Just for some further details, we're handling evictions throughout Western New York, and some courts are open and accepting filings. Some courts are open and actually holding hearings. Other courts are not opening at all yet. So it depends on a particular court. Justin can give you a rundown of what his experience has been with so far, which courts have been open that he's been in.
So yeah, this isn't an exhaustive list by any stretch of the imagination, but just as far as the major cities around here go, city of Niagara Falls, they have been accepting eviction petitions and hearing them relatively quickly. All of Monroe County, all the justice courts are sending all of their evictions to a special part of the Monroe County Hall of Justice, and they've been processing those rather quickly as well. So if you're attempting to evict anyone in Monroe County, you shouldn't have a problem getting a date there. Again, the biggest holdout has been the city of Buffalo. As I mentioned before, they are now hearing petitions that were filed in October of 2020. We're getting dates for those in July, and they're giving priority to petitions that have been filed with the nuisance exception. As far as town courts go, Cheektowaga, West Seneca, we've been in and out of there. Some other courts have been holdouts on giving dates, but if you give them a call and say, hey, it's a nuisance petition, doesn't apply to the moratorium, you might get a date. That was the case in Orchard Park. We were waiting a real long time on a pretty bad nuisance petition. We gave them a call, let the clerk know what was going on, and they got us a date. We were the only ones in there. So sometimes that's all it takes, is just to talk to the clerk. The town of Ridgeway in Orleans County, we got a date very shortly after serving the notice. Bemis Point. Again, I think maybe the smaller the court, it seems, the more likely you'll be able to get in there. Town of Clarence, they are not hearing any evictions, and they have not been susceptible to any of my begging and pleading. I believe the same is the case in the town of Newstead. So that's pretty much everywhere that I've been in and out of or have been denied access to and still patiently awaiting. But again, if you have any further, more specific questions, feel free to give us a call or send us an email, or put a question up here and we can answer it after the fact. Thanks again for joining us tonight. We'll see you in a couple weeks.
In case you missed anything, the video of this webinar and the PowerPoint will be available on our website, WNY-Lawyers. If you have any questions about evicting tenants or leases, feel free to give Justin or me a call. And thank you for joining us tonight, and we'll notify you when the next webinar is scheduled.